one other point that I wanted to comment on is the notion that when it comes to fundamental, to international human rights, there are two systems of rights. One which is called the first generation, and the other which is called the second generation. That proposition has been repudiated time and again on numerous occasions. If you look at the Universal Declaration of Human Rights, it is premised on the assumption that there is one system of human rights, and that's why they're all contained in a single document. There is no separation between these rights. And on numerous occasions, and I think it was in Pretoria, where the Constitutional Court underscored the indivisibility of the rights contained in the Bill of Rights. On that occasion, we made it quite clear that the right to vote is utterly meaningless to a person who can hardly go to the polls to cast his or her vote simply because he's too ill to go there, or too frail to lift his or her hand in order to make that mark. We underscore the indivisibility of these two systems. It is true, there is a long literature, in particular in the US, which seeks to make a distinction between socioeconomic rights and civil and political rights on the one hand. The usual argument is premised on a fundamentally flawed notion that the one set of right is positive in the sense that it requires government to take action. Socioeconomic rights, they say, require government to provide housing, to provide health care, and therefore they are distinguishable from civil and political rights, which requires the state to refrain from interfering with the individual. The fundamental problem with that is that both these sets of rights have both the negative and the positive aspect. The right to vote, for example, is not about going to the polls and making a cross. It is fundamentally about the obligation of the state to put in place the entire machinery that will enable people to cast their vote. From that perspective, it requires the state to take positive action in order to give effect to that right, as opposed to the negative aspect of the right, which requires the state to refrain from obstructing that, as was the case in the prisoner's case. If you go to the other example, is an example relating to the right to a fair trial. The right to a fair trial requires the state to take a positive action to put in place the entire criminal justice machinery with prosecutors, with the police, with everyone, so that all of us can exercise the right to go to court and have our dispute resolved in a fair and impartial manner. And to that extent, the right to a fair trial, which is classified as a civil and political right, has a negative as well as a positive right. The right of access to housing, which is a socioeconomic right, which critics say has a positive aspect to it because it requires the state to provide housing. It too has a negative aspect. It requires the state to refrain from any conduct that tends to obstruct access to housing. the case of Jafta and Schoeman is a case in point where the Constitutional Court made the point. So I think what we need to do, we need to view these sets of rights as one set of rights, which inform one another in order to make a whole. We need both these sets of rights in order to give effect to the Bill of Rights. And then the final aspect on which I want to comment. I'm not going to comment on the market inquiry and what it seeks to achieve. Because that's a matter which I will have to decide the next couple of months or so. But I will say this now. When it comes to competition law and policy, it's very clear. Begins by recognizing our past. It does so because it's a South African statute. It just cannot ignore our history and pretend as if when we were all born, we were born into a constitutional democracy when we had everything else. It has to recognize that there are individuals who were precluded by law and by conduct from taking part effectively in the economy of this country. And against that background, it requires the law to facilitate their entry in order to enjoy the fruits that all the others have been enjoying for years, held by the law. Section 9 of the Constitution, which deals with equality, recognizes that our equality conception is not formal equality, but it is substantive equality. That is why it makes it quite clear that equality includes measures that are taken in order to redress the imbalances of the past. That's what the Constitution says. Had it not been for Section 9(2) of the Constitution, which requires the redressing of the racial imbalances and gender imbalances of the past, the Constitution would have been fundamentally flawed in the sense that it would have made a false assumption that all of us were equal, when in fact, and in reality, we were simply not. There were others who were 10 years behind, and others 10 years ahead. It recognizes that. It requires the state to put in place measures to close that gap, so that we can enjoy the benefits of the society that is foreshadowed in the Constitution, and that is the society, the new society, by the way, which is based on social justice and fundamental freedom for all, not for one group, but for all. There was a question about the role of the judges. I prefer to see a role of a judge as being deeply rooted in the oath of office that a judge takes, which is in the Constitution, and that is to uphold the Constitution and the rights that are in the Constitution. We need to hold the scales of justice evenly balanced to make sure that we are impartial and independent. We need to administer justice without fear or favor, but we are with our eyes firmly in the Constitution in order to give effect and transform this society to the one that is envisaged in the Constitution. Because if we take our eyes off the Constitution, that society will be elusive. Thank you.
Let's give a job. I think that's unless you have something exceptionally pending.
Can I respond to Claire's question?
I beg your pardon?
Yeah, Claire asked me a question. Can I respond to it?
Yeah, what I would like to do is to just do brief closing remarks. You can incorporate that in your question, and you do the same as the panel, and we close it there.
Okay, so just so you can recall, so I'm not speaking just to Claire. Claire was asking about, haven't we already done that, and how can we differentiate markets that are socioeconomic rights? So my response to that is twofold. I think that the Commission and the Tribunal have done exceptionally well in a lot of areas. So which categories they focus on, they've done very well, and I was complimenting them on that. On the principles of constitutional law, so the Chief Justice said now, statutory interpretation is required to be infused with constitutional principles. There is not, and I know that, I challenge you to contest me on this. There is no single judgment of the Tribunal that infuses statutory principles with the Constitution. Explicitly or implicitly, it doesn't exist. My challenge is for them to do that, okay? And I, to close, would say that the context which we've been talking about now, and the context which the Chief Justice brought out, I think that we need to realize just how serious it is. And I was hoping to use the example of the market inquiry and patients' healthcare, like the lady with the hip replacement, to show that this very academic issue on the ground results in someone actually not having a hip which they need. But to put it more in perspective, in 1994, when we became a democracy, 80% of the JSE was owned by 6 white families. That's a fact. That's not an ideological point. And the question is, would a Competition Act in South Africa ever have been legitimate if what it did was just allow for a start over and now efficient markets must run efficiently? And the answer, quite simply, must be no. That's well recorded in the history of the Act and well recorded in the people that were involved in drafting the Act. What we have, unfortunately, in my view, is a situation now 20 years on where we've forgotten that. And now we're having a live debate about whether or not the Competition Act is supposed to transform, to contribute to economic transformation. That wasn't a live debate in the minds of the drafters of the Act. We need to interpret the Act in light of the Constitution, and we need to make sure that the continuing injustices which exist, as much as possible, which I understand is limited, and Chris is very right about that, as much as possible are infused with constitutional principles.
Thank you very much. You have the last word.
Thank you, that's what we like. I think, look, it's a very broad topic, and it's a huge, vast landscape, and we've picked out some of the battlegrounds. But I think, just for me to close off on, I think what I want to say is this. I think that the Competition Act, without doubt, has its roots in, like any legislation, must have its roots in the Constitution to some extent. And I think, in the realm of socioeconomic rights, it goes without saying that the Competition Act falls squarely within the principle of progressive realization, which is really how the Constitution envisages socioeconomic rights to be informed and to be driven. But at the same time, the Competition Act is an act, and therefore the Competition Commission is a creature of statute. And therein lies, whether we like it or not, some limitation. And those limitations are that the Competition Commission is at the same time both a investigatory body and a prosecutorial body, which is fine, and as it should be. But that necessarily means that you're going to look to the judiciary, the tribunal, and the Competition Appeal Court to keep an eye out, to put some brakes on that. And if that happens, therein lies a very legitimate limitation on the powers of the Competition Commission, which is why all I'm saying ultimately is you cannot look to the Competition Commission to be the savior of the socio-economic
Yes, and they won't change capitalism into socialism. That's a method that can be decided elsewhere. Over to you, Mr. Scott. Thank you. Let's give a round of applause to the panel.
Thank you very much. Thank you very much, David. And thanks very much to everyone. I'm not going to call upon our Deputy Commissioner to a vote of thanks, because I think that we've been thanking each other the whole day. This has been a very important occasion, a very insightful way of celebrating Human Rights Day, and we hope that we will hold each other's hand in other activities that are national and share these insights. Thank you very much to everyone. We would like to have teas.